Hi, my name is David Sobel, and I'm a real estate and finance attorney here in Michigan. Each week, I receive legal and real estate questions by email from viewers from all over the country, as well as right here from my state here in Michigan. This week's question comes from Jim Stark of Oakland County, Michigan, and he writes that he's in the process of selling a home. He says, quote, "I currently have a tenant in the house, but I agreed to make sure that the home was vacant at the time that we would be closing. But when we got to the day of closing on the home, the tenant was still in the property and would not leave. So according to Jim, he says, my tenant says she needs an additional 2 weeks to vacate the property, and that's a problem. So now what's happening, according to Jim, he says that now the buyer has refused to close because the home was supposed to be vacant at the time of the closing. And the buyer's agent is now yelling at us, threatening a lawsuit if I don't get the tenant out immediately. What can I do? How do I get to this home to the closing?" That's a great question, Jim, and I'm really sorry for your circumstances. This is a very common occurrence, especially in these past several years when homes were being rented out when the market was not that great. Now the market's wonderful and people are trying to sell their homes. So first, if the agreement called for the home to be vacant before you conveyed the title, then the agent's actually correct. You breached the purchase agreement by not having the tenant out of the property in a timely fashion. Second, you could close an escrow, but if if your buyer is financing the home, it's very unlikely that the mortgage company will allow a closing to occur in escrow. And what closing in escrow actually means is that the transaction is really completed, but while the documents are signed and the monies are funded for the transaction and they're collected, the funds are actually not dispersed until a condition that's been agreed upon between the parties. And that could be the buyer, the seller, it could be the title company, it could be the finance company. Until those conditions are met, none of the monies get dispersed. So in this case, Jim, the condition that you would have to deal with is to get the actual tenant out. So practically speaking, when selling an investment home, sellers should wait to actually put their home up for sale only after their tenants have left. And not only does this ensure that the tenant is out, but that the tenant doesn't actually damage the property while the property is actually being marketed. I mean, that can be a big problem. So now, if you can't escrow the funds in a closing, you could actually offer the tenant money to leave immediately, something called cash for keys. Usually that's not in a landlord-tenant scenario, but more in a foreclosure situation. But in this case, you could offer the tenant, or you can offer the buyer money to cover the cost of the eviction, along with some other monies for the inconvenience and time. Now, if I were the buyer's attorney, I would actually advise against closing on the home. I'd tell the buyer, don't close on the home until that tenant's actually been evicted. I would never have my buyer ever assume the responsibility or the legal obligation to evict the tenant, because the tenant actually could have some legal defenses against the seller that are unbeknownst to the buyer, and that could really prolong the legal process. Why would a buyer actually want to purchase a lawsuit? So Jim, as a seller, you did make a critical mistake. But you could delay the closing and you could offer the buyer some funds to cover any financial inconvenience and then get the tenant out. Ideally, the tenant can leave on their own accord immediately if you pay them enough money to leave, or what you're going to have to do is you're going to have to simply evict. And the legal process there can be very short, or it could take up to 45 days depending on the terms of the lease. So it's something for your consideration. Well, I hope you found this information helpful, Jim. Sometimes the answers are really never easy, and this is not an easy scenario. And for those of you who are still watching, if you like this video, please care to share it with your friends and your family and your coworkers. You can also leave a review on what you liked about the video, and you can also feel free to write in a comment right underneath the video in the comment section. Write other topics that you'd like for us to discuss, and if you wish to submit your own legal question, like the one that Jim just did, then just email us at team@provenresource.com. Or you can go and you can call in the question to 888-789-1715. Also, I want to let you know that I just released a new book called Shady: How to Protect yourself when doing business with friends or family and relatives. And you can download this book for free by going to our website, which is provenresource.com. And it's a pretty straightforward book. It's relatively short to read and easy information, very practical for people who are looking to engage in new businesses. Finally, I never assume that you need anything from me, but if you have any questions related to real estate law, contract law, or financial disputes, please feel free to give us a call at 888-789-1715. I'm David Sobel, and again, thanks for watching.